Mr. Geller.
If it please the Court. My name is Roger Geller. I am an assistant bar counsel here representing the Office of Bar Counsel in this bar discipline matter. The issue in this case is what is the appropriate level of discipline for a lawyer who makes misrepresentations that go to the heart of the fiduciary relationship between the lawyer and the client. In this case, the attorney made 4 written misrepresentations to his client concerning the amount of money he had recovered on the client's behalf.
Well, I have a question that goes right to the heart of this, I think. Mr. Doe's brief says that the hearing committee found that the other attorney, McBride, did not convert the client's funds, that he was not necessarily aware that Mr. Doe was not necessarily aware of the commingling, that he had no authority over the handling of the client's money in the firm, and that as an associate and an inexperienced attorney, he shouldn't be held responsible for McBride's handling of client money, and that the only thing, according to Doe's attorney, that Doe was responsible for is the misleading statement to Vaughn Wood that he was concealing from Vaughn Wood and from bar counsel. Now, is that correct or not correct?
Well, in the first place, it's not correct. In the first place, Mr. McBride, there's an opinion by Justice Sossman that Mr. McBride did convert the client's funds in this matter. He took a fee before he was entitled to it in direct contravention of an agreement that Mr. Doe had reached with the clients to hold their funds, to collect them, and to distribute them on a quarterly basis. When it came time to distribute those funds, Mr. McBride told Mr. Doe that he was not going to distribute all $100,000 that had been recovered, but in fact was going to distribute only $50,000. And that is the misrepresentation that Mr. Doe made to the clients. The amount that had been...
But is the finding... Now, Justice Sossman's opinion didn't refer to what Mr. Doe did vis-a-vis all the remaining clients. Are we governed by the finding of the board that Doe only deceived Vaughn Wood and bar counsel and not the other clients?
It doesn't matter whether Mr. Doe deceived all of the clients or one client.
Well, I don't know whether it does or not, but I'd like to know.
He had 17 separate clients, 17 separate contingent fee agreements, 17 clients with separate claims against a common defendant. So this wasn't a class action case.
No, I understand, but you are avoiding the answer to my question.
I'm sorry, I don't mean to.
Are the findings that we're bound by, because that he deceived all 17 clients, or that he only deceived Vaughn Wood and bar counsel?
You are bound by the hearing committee finding that he deceived Vaughn Wood is binding. I believe the hearing committee decision that the other clients were not deceived is subject to question, but even if that is binding on this court, it doesn't matter, because there is still misrepresentation as to Doe. As to Vaughn Wood.
I agree with you.
Mr. Geller, it surely makes a difference in this sense. If there were, 17 different misrepresentations, that's a pattern of conduct, at least as, and you may not accept this, as I understand it, the client Vaughn Wood was, at least from this attorney's point of view, a difficult person. He didn't want to confront him. He didn't want to, as I understand his position, he was caught between, as it were, the partner in charge, the senior associate, the senior attorney, telling him what he was going to do. He didn't have control over the funds, and I'm not saying he should not have. It was okay to make the representation, but it's not the same thing as if he made 17 phone calls.
Let me just address whether or not Mr. Vaughn Wood was a difficult client. Mr. Vaughn Wood complained. He complained that he hadn't been told that money was collected in the first place back in October. He complained that...
well, why does it make a difference whether he's a difficult client or not?
I don't think it does, and I don't think he was a difficult client. All he was trying to do was get what he was entitled to and to honor the terms get Mr. Doe to honor the terms of an agreement that Mr. Doe had made with him.
How could Mr. Doe have honored the terms of the agreement? What was he to do with Attorney McBride? Grab him by the collar?
He was supposed to grab him by the collar and say, what you're doing is wrong.
Turn him into the Board of Bar?
His responsibility was to his clients. That's correct, Your Honor. He had no right to participate with Mr. McBride in withholding funds.
So he acquiesced, basically.
Not only did he acquiesce, but I would say that he abetted it, because but for these misrepresentations to Mr. Von Wood, Mr. Von Wood would have complained again. Mr. Von Wood would have insisted on having the agreement that Mr. Doe struck with all the clients honored. And he would have, he could have then complained to Bar Counsel about knowing all of the information, that funds were being withheld from him. And Mr. Doe had an obligation to tell him the truth.
As I understand the findings, is that he did tell some or all of the other.
He told one or two the first day, and he told 3 or 4 within a week, and he had the expectation that the clients talk to each other and that they very well may have shared this information amongst themselves.
How much slack do we cut him, in your opinion? I already know the answer to this, I think, from the fact that he's a rookie.
I think rookies get some slack when it comes to certain rules of professional conduct. The rule against lying to your client, I don't think you need to be an experienced lawyer to know that that's wrong. Mr. Doe came from a history in business. He was a stockbroker. He knows that it's wrong to lie.
Can I ask you a question about the conversion itself, and in particular whether it was temporary or permanent? If the fees had been paid out to the clients as the lawyers had hoped they would get paid out,
you mean the judgment, the award?
Yeah. Would the clients have received the fees that they would have been entitled to under the contingent fee agreement?
If Mr. Bleck had honored his payment agreement and made all of the payments, was the testimony at the hearing that Mr. McBride intended to pay the clients their net share out of future payments.
But they would receive the share that they would have expected to receive under the written contingent fee agreement.
Eventually, yes.
Okay. Okay.
That's what the agreement that Mr. Doe struck with the clients
Yeah.
after that first payment had been received, and Mr. McBride, we say, appropriated that to his own use.
Now, did they in fact receive the money that Bleck actually paid out? Did they receive what they would have been entitled to receive of that amount under the contingent fee agreement?
Eventually they did, but they were deprived of those funds from the time of the second payment.
I understand that.
Until ultimately, maybe 4 or 5 months later, when Mr. Bleck was forced into bankruptcy, and it became manifestly clear that he wasn't going to be paying anything else.
And I'm just trying to get a perspective on this. And the worst case scenario, the deprivation, is a temporal deprivation.
Absolutely.
It was not a permanent intent, or intent to deprive them of money permanently.
Well,
or was it?
We don't know. For purposes of argument, there was.
What did you prove? That it was temporary?
There was only temporary deprivation.
One point that I don't think you make, and it's just a hypothetical, but yes, this was only a temporary deprivation, but if the firm's success all of a sudden went downhill, there wouldn't have been money to pay back.
Absolutely, that's right. Mr. McBride had to go back into his pocket to get this money. Now, Mr. Doe didn't know necessarily where Mr. McBride had put those funds, but he did clearly know in December, after that second payment was made, when it came time to distribute to the clients their share of $100,000, and Mr. McBride said, no, we're only distributing $50,000 to the clients, or their share of 50, and I'm going to keep the other 50.
Yeah, but what is he supposed to do as an employee?
He's supposed to say that that's wrong. That's not what we agreed.
And where would he be the next day?
Fired.
He may be fired, but he would at least be acting in an ethical manner here.
I thought he did say that was wrong.
He
I thought
did remonstrate, the findings were that he
What does remonstrate
remonstrated. He urged
That's wrong.
He didn't grab him by the lapels and shake him, but he did say, this is wrong, this is not what we agreed, and Mr. McBride said, I don't care. And then he followed that, instead of continuing to argue with Mr. McBride or to refuse to write these letters, he wrote 4 letters to the clients that misrepresented the amount of
So what do
money
you
that
say
had
the
been
penalty
recovered.
should be?
Pardon me?
Penalty, indefinite?
No. We
2
say 1 year and 1 day. And the reason we say that is because a year and a day requires
I know, reinstatement.
reinstatement proceeding. And I think that this facility to make a misrepresentation in order to keep your job or put your own interests ahead of your clients is wrong enough so that the bar is entitled to make sure that this attorney has the learning and the requisite knowledge not to make this kind of a mistake again.
And both the hearing committee and the board recommended a private reprimand?
That's correct. And we think that private discipline is just an anathema when it comes to making a misrepresentation that goes to the heart of a fiduciary relationship.
And by the way, this was his very first job.
He practiced
He
for
practiced
himself
on his-
for a
on
little
his
while,
own
and then
for-
he got a job with Mr. McBride.
So this
That's
was
right.
his first job.
Correct.
Thank you.
Thank you, Mr. Geller.
Thank you very much.
Mr. Todd?
May it please the court, Owen Todd, and I appear for the respondent. Excuse me. Sadly, a young, inexperienced lawyer committed an error of judgment when he was forced to do so in a very difficult situation. I think it's very important, Your Honors, to place Mr. Respondent in context on December 19th, 1997. He had just returned from New York, where he, through his own personal efforts, and sitting outside Mr. Black's office all day long and shooting into his office at every opportunity, he had managed to get an extra $50,000 from Mr. Black on the payment of the judgment. When he came out of that office with the promise of getting $50,000, he got on the telephone and he called one of his clients to say, I got another $50,000 out of Mr. Black. And the testimony was that he called 2 others on that day. Then he returned to his office and there met Mr. McBride and told him $50,000 was on its way. It may have even been received by that time. And Mr. McBride ordered him to distribute $50,000. Ordered him to do that on the same day that he had gotten the money from Mr. Black. On that same day, he did distribute the money. In a letter dated December 19th. There is no representation one way or the other in that December 19th letter. He just said, enclosed, you will find checks for $50,000. Either just before that or just after that, he got on the telephone and he called Attorney Ligario, who had referred the case to him and who was a close personal friend, and said, John is not going to distribute the second $50,000. What should I do? Hold on. The testimony was, he was told, hold on, persuade him to do it. He then called, and he could only remember the names of 5 clients that he had called. This hearing was 5 years later. He said he had, excuse me for coughing. He said he had called, he thought he had called nearly all of them, but he could only remember 5 names of others that he called. And there had been testimony and findings, both by the hearing committee and the BBO, that these brokers were conversing with one another, including Mr. Van Wood. Wood was in this network. So Mr. Respondent had every reason to believe they all knew. But he wrote this letter on December 19th, and he did not say, and I've got another $50,000 in that letter, because that was a letter he knew that Mr. McBride, his employee, was going to read.
Was there anything in, any evidence in the record at all to suggest that Van Wood knew, in fact knew, that the second $50,000 had
No. No, there wasn't any one way or the other, and I'm assuming he didn't know.
He didn't know what, that the
that the
That the
second
second
$50,000
$50,000 had come in. The board took the position that Mr. Respondent had no way of knowing one way or the other whether Mr. Van Wood knew, and that's why he would not lie had Mr. Van Wood, who said, he told me he didn't, and the board said that, the hearing panel said, we don't believe that.
Well, it's one thing to say that maybe he's a young and inexperienced lawyer, and therefore he was acting at the behest of his employer when he deceived Van Wood. But what about when he is a lawyer and he gets a request, a letter from Bar Counsel that a complaint has been filed, and he's asked to respond, and he deceives Bar Counsel?
First of all, I think it's very critical that that I articulate the fact that that was not charged in the petition for discipline. We never knew until we got there. And the evidence was on that that was part of the case. And I objected at the time that we weren't charged with that.
Did you make that argument in your brief?
Yeah.
You made that
Yeah,
argument
it's
that
in
you
the
weren't
brief.
charged?
Yes. But we weren't charged with falsifying anything to the Bar Counsel's office. More than that, that letter was written under direct orders. You respond to this petition for discipline, to a letter of inquiry, and answer only the questions they ask. That was the instructions he got from his employer on how to respond to that. 3 subsequent letters to the Bar Counsel he did.
I take it, and I don't have the letter in front of me, but I take it that the letter is literally accurate.
Literally, but
I mean, I didn't disclose that there were two $50,000 payments, but that really wasn't the question, was it?
no, the question was what about the expenses. It was only a collateral matter.
How much expenses should have been charged by the
Yes.
firm versus the
Correct.
original contingency fee agreement?
The complaint against the firm was that they had charged fees for expenses, rather, and they shouldn't have. And indeed, they should have, because the hearing committee found that all of the clients,
Well,
including...
Mr. Todd, do you say that a rookie, a person in their first job, they get a free pass?
No, they don't get a free pass. He was sanctioned, Your Honor. After the hearing panel heard this, they imposed a sanction on him, as you know, a private admonition. And then when the Board of Bar Overseers reviewed it, unanimously, they said, yes, he should be sanctioned with a private reprimand. So he's not out scot-free. He was sanctioned. Not to mention, 9 years this has been pending, and with that stress, financial and emotional. He has learned a very, very important lesson. But he's in this position, I ask this court to let's not put an old head on young shoulders. He's in a position where his boss said, this is what I'm going to do. He tells his clients and his consultant, his mentor, what am I going to do about this? Get John to change his mind. And he thought he could. And if he couldn't, the money would have come in with Bleck, and it would have been academic. So he had spent this time, this interim, trying to persuade his employer, do what you did. Don't remember, this was a breach of the agreement with the clients by Mr. McBride and a breach of the promise to this young man. I promise you that when the day comes, I will have the money. John, you'll have to have the money.
But what would happen if the firm had a very bad year or two and there wasn't money to repay? That's happened.
But the evidence was that Mr. McBride had a very substantial personal estate, wealth. He had a big account into which all of these fees would go, and he would trade with it. So
Well, at what point does that stop? If the associate has been working there, working with a lawyer for 10 years, would you make the same argument if there was 10 years experience?
No, I wouldn't obviously make the same argument in those facts. But remember, I believe all of the cases that I have found that are at all similar, O'Malley, Keefe, Malowitz, and so forth, where there is misrepresentations to the courts, clients, and so forth, have said public reprimand. And that's what the BBO said they would have considered but for these mitigating circumstances. But to say that it would go beyond a public reprimand, it would be disparate with an entire string of cases. So no, I don't suggest that. I suggest that the way that both the hearing panel, which was really an incredible panel, detailed, took everything into consideration, passed a beautiful opinion, passed muster with the BBO. The way they passed was all the cases suggest public reprimand in these situations. But this is even less than that, because there was never a direct statement of a lie. For instance, there was no other money. This was all the money we ever got. It was a failure to disclose. And this court, in several cases, none of which I can name right now, has indicated that there is a distinction between a direct lie to a tribunal and where there is a failure to disclose to something other than a tribunal. Incidentally, I failed to introduce Mr. Edward Foye, who is the author of the brief that we submitted. In any event, Your Honor,
But there's also a distinction between failure to disclose to a third party and failure to disclose to a client, isn't there?
I didn't hear you.
Is there a distinction between failure to disclose to a third party and failure to disclose to a client in terms of comparable sanctions?
Apparently not. There was one case I read where the lawyer made a misrepresentation to a third party, bank, I think it was, or a broker, where it was, the distinction was not made. But there is a distinction made, and a sharp distinction has been made by this court between misrepresentations to clients and misrepresentations to tribunals. And the cases that we cite in our brief point out misrepresentations to clients and bar counsel, clients and bar counsel, clients and bar counsel. Half a dozen of them we cite, and they're all public reprimands here, but for this mitigating circumstance, that probably would have been what would have happened, except for the fact that he was in this jam. And an important finding of fact, a critical finding of fact by the hearing committee and enunciated or supported, verified by the unanimous decision of the BBO, was a finding of fact of intent, that the respondent never intended by his letters, anything contained in his letters, to deprive the clients of any money, to aid or abet the deprivation of any money from these clients, but rather his intent was to delay a confrontation with a difficult client, according to the BBO, their words, until such time as he could either work it out or the money would have been paid. It was not a matter of deprivation, but a timing of payments was the finding of fact. And the Board of Bar Overseers felt that it was bound by that finding of fact, and I think it is a critical and most important finding in this case.
Now, this occurred 9 years ago?
Yes.
December of
1997.
Early 1998, yeah. Is your client still working as a lawyer?
The client is working for a lawyer.
Working as a lawyer for a lawyer?
No, he's a sole proprietor now. He has a good practice in personal injury cases. So he went from a temporary lawyer for 6 months, where he was house painting principally, and getting referrals from people. 6 months later, he's with Mr. McBride, very high profile, very successful lawyer, everything that he had hoped he would become associated with Mr. McBride. 4 years later, he's in very big trouble, and 5 years after that, we're before this court trying to reserve or protect the sanction he received.
Mr. Todd, may I ask you a factual question? And forgive me, because, as you know, the next case up, or you may not know, concerns Mr. McBride. In your proceedings and the proceedings for the respondent here, was an issue made of the fact that there was a failure to obtain the client's permission, the 17 clients, for the negotiation with Mr. Black to pay out?
That was made, and the hearing committee and the BBO found that Mr. Respondent was no part of that. He didn't negotiate that settlement. He didn't approve of that settlement. And the day that he learned of that settlement, he got on the phone pursuant to his instructions and told all the clients, Mr. McBride has worked out an agreement whereby. So they found that he had no part of that settlement. And when he found out about
Mr.
it...
Todd, I just have a question. I understand that you say that Bar Counsel didn't charge your client separately with the misrepresentation to Bar Counsel. You make that statement in a footnote in your brief, but you didn't make that any argument, part of your argument, that he shouldn't have been found to have misrepresented to Bar Counsel. I just found it. It's in a footnote at the very end of your brief.
I'd be disappointed if it wasn't...
But it's a fact, he wasn't charged with that.
No, he was not. You can look at the petition.
It's on page 39 in a footnote 21. The board did so being that the finding that he a violation of the rule because he concealed the second payment both from Mr. Vaughan-Wood and from Bar Counsel, and fully considered that conduct in formulating its recommendation for discipline. Footnote says, the board did so even though Bar Counsel did not even charge respondent with making misrepresentations to Bar Counsel. But you didn't actively argue that you didn't have a chance to defend against that or anything like that.
Well, I raised Cain down
At the hearing
beneath
committee.
when they wanted to go into it.
Sure.
I just mentioned gratuitously, it is a common thought, where Mr. McBride felt he was entitled to keep his fee up front until such time as it was paid, that it is not uncommon, I find, in mediating cases that most lawyers feel the same, that where there's a structured settlement.
Because if the firm goes bad,
I
they're
know,
not going to have the money.
but maybe that's something that should be dealt with in an opinion.
Well, yeah, it was dealt with in the contingency fee agreement.
Was it?
Because the contingency fee said actual receipt of funds or non-cash benefits. So I think in this case, and that again may not have anything to do in the McBride situation.
But everybody in these structured settlements, the lawyers always get their fees up front, and it might be 10 or 15, 20 years before clients get them.
Well, is that provided for in the?
No. But it's every case I mediate, that's what happens.
We shall
Thank
take
you for your
judicial
time.
notice of that.
I'm
We
sorry?
will take judicial notice of that, Mr. Todd.
Well, Happy New Year to the court.
Thank you.